Inmate would reform informant recruitment. By Carlos Galarza VEVE. Staff writer. Punta Gorda, an inmate alleging he was badly mistreated while confined at the Charlotte County Jail this summer wants to use his pending criminal case as a platform to reform the way he says law enforcement agencies in Florida manipulate confidential informants in the seemingly never-ending war on drugs. Mark Kopaszynski is requesting through his attorney for the court to investigate his claims of misconduct by the state attorney's office, the Charlotte County Sheriff's Office, and/or the Federal Drug Enforcement Administration in the way these public bodies recruit and rely on the work of informants. According to the 57-year-old Kopaszynski, recruited informants are too often mentally ill, or are themselves heavily dependent on drugs, as he was when he worked as a confidential informant. In a related legal maneuver, Kopaszynski's attorney Mary E. Fitzgibbons is asking the court to disqualify the state attorney's office from participating in her client's inmate Pipe 9. Inmate. From page 1. Post-conviction relief case. Fitzgibbons argues that the state attorney's office is tied too closely to Kopaszynski's underlying drug cases for which he was sentenced to prison in 2013 for 15 years, after he pleaded no contest. At the time he was arrested and charged in separate cases filed in 2011 and 2012, Kopaszynski was still working as an informant. Fitzgibbons raised her arguments in two court motions filed October 4 that address issues related to her client's case. She did so a week after Circuit Judge Donald Mason recused himself from hearing Kopaszynski's case, in which the inmate is trying to vacate the sentence imposed on him in 2013. At the time Kopaszynski was being prosecuted on the drug charges, Mason headed the felony division at the state attorney's office. One of Fitzgibbons' motions deals directly with asking Circuit Judge George Richards, who was assigned to Kopaszynski's case, to reconsider the disqualified judge's orders. One of those rulings by Mason was a decision he made during a ruling April 6 rejecting Kopaszynski's request for a full investigation into the inner workings of law enforcement's use of confidential informants. The Sun obtained a digital recording of the April 6 hearing through the state's Public Records Act. He, Kopaszynski, wants it to be known to Your Honor that law enforcement is unleashing untrained persons into Florida streets as informants, Fitzgibbons told Mason. He, Kopaszynski, is a mentally disturbed person. He wants a full investigation. He's alleging that law enforcement was encouraging him to commit crime, winking at crime. Mason interrupted the attorney. Aren't these all issues underlying the original case that have been resolved? Mason asked. It may have provided some entrapment defense at the time, but this court is not in a position to consider those issues in a post-conviction posture. Fitzgibbons argues in her recently filed motion that Mason's ruling was made of his own accord and should be vacated. Where, as here, a judge's remarks demonstrate he has prejudged the case, it has been held sufficient to require judicial disqualification. The attorney wrote. To the extent that such remarks may have represented a highly questionable and improper ruling in prejudgment of this case, defendant requests that any such ruling now be vacated. Fitzgibbons, in her other motion, argues that Mason's conflict of interest extends to the state attorney's office. Under these facts, this state attorney's office cannot ethically and/or objectively litigate, much less evaluate defendant's claims. Fitzgibbons wrote. Therefore, defendant moves that the SAL be removed from representing that state herein due to conflict. The state attorney's office has not responded to the motions, nor indicated whether it plans to assent or challenge Fitzgibbons' request that it bow out from the case. As a policy, the state attorney's office does not comment on active cases, spokeswoman Samantha Sion said. Judge Richards has yet to schedule a hearing on the matter. Kopaszynski's case gained notoriety 2 months ago when the Sun reported an incident at the Charlotte County Jail in which the inmate allegedly ate his feces while corrections deputies watched and laughed. Sheriff Bill PRUMMELL, whose office oversees the jail, fired one deputy, and reprimanded others who were required to undergo more training. After the court found Kopczynski mentally incapable to proceed with his legal defense, the inmate was placed at a forensic hospital to recover. He is now at the Wakulla Correctional Institution near Tallahassee. Judge Richards ruled that Kopczynski is now fit to proceed with his case after a competency hearing in early September. The sheriff's response to Kopczynski's incident apparently had little impact on another corrections officer currently under investigation by the sheriff's office. Jail and sheriff's officials recently identified the corrections deputy under investigation as Christine Schmidt, but declined to say what is the nature of the complaint against the corrections deputy. Sheriff's spokesman Skip Conroy said he could not give a timetable for when the investigation of Deputy Schmidt would be completed. "There is an investigation that is ongoing against that deputy," Conroy said. "No details of the investigation will be released until that case is completed." Prummell said this week he was unaware of the new developments in the Kopczynski case, and had not seen the motions filed. However, he addressed the matter of confidential informants. "It's not our policy to recruit mentally ill informants," Prummell said. Nonetheless, the sheriff said that to combat drug trafficking, informants are recruited from a pool that includes drug dealers and users who may have mental issues that are masked by their addiction. He said these individuals agree to become informants for various reasons, including wanting to kick their drug habits, end a life of crime, or cooperate with law enforcement to get less time in prison or avoid prosecution. "It runs the gamut," the sheriff said. The sheriff added that there is no training for confidential informants. He said the training that takes place is for the benefit of sheriff's deputies who supervise the informants. Fitzgibbons said Kopczynski wants to shine a light on the problem. She drafted legislation at her client's behest requiring that medical professionals intervene in the recruitment of informants to screen out the mentally ill. Indeed, in a case like this, the public interest demands a thorough, independent investigation of any and all misconduct by the State Attorney's Office, the Charlotte County Sheriff's Office, and/or DEA in these cases. Now, notwithstanding this is an election year. Email galarza@sun-herald.com